Before we even hear the first word from the bench, understand this. Today's courtroom is about boundaries, credibility, and consequences. What starts as a routine bond discussion quickly spirals into a chilling pattern of ignored court orders, repeated violations, and judicial patience wearing thin. We're dealing with a young defendant, complicated mental health issues, and a court system trying to balance fairness with public safety. Meet Demetrius Caldwell, a defendant who has already missed multiple court-ordered forensic interviews, a crucial step in determining how his case will proceed. These evaluations aren't optional. They're ordered to assess mental competency, ensure due process, and determine whether the court can even move forward. And when someone repeatedly skips them, that's not just inconvenient, it's a violation of bond conditions. The prosecution is fed up. The defense is scrambling for explanations. And the judge? The judge is walking a tightrope between compassion and enforcement. What makes this case even more volatile is the emotional tension you're about to witness. From courtroom decorum being tested, to a defendant who refuses to respect authority, to outbursts that force the judge to draw a hard line. This hearing turns into a masterclass on how quickly patience can run out in a courtroom. So the real question is, how many chances does the court give before consequences become unavoidable? Watch closely, because this case isn't just about missed appointments. It's about respect, accountability, and what happens when the system finally says enough.
I heard you. I heard everything what you said. You don't gotta explain it no more. I heard you, bro.
Yeah, I'm not
you
bro.
And I will be there.
I am not bro. I will never be your bro.
I didn't say bro. I said all right.
Do not refer to me that way, because we're gonna have a bigger problem.
I didn't say bro.
Court calls the case, People versus Demetrius Caldwell.
Ashley Feltus for the people.
And good morning, or good afternoon, Your Honor. Sydney Rushing appearing on behalf of Mr. Caldwell. Mr. Caldwell, can you unmute your mic and state your name for the record?
Demetrius Caldwell.
All right, thank you. What are we doing?
Your Honor, the last time we were here, we scheduled this matter for a forensic interview. That date has came and it has passed. Unfortunately, Mr. Caldwell did not make it to that interview. We're going to need a re-referral.
Your Honor, I think this is at least the second one he's missed.
Yeah, why is he missing the interviews?
Your Honor, I am unsure as why the one was missed on November 3rd. I did have an opportunity to speak with his guardian ad litem, Ms. Graham, who is on here today as well. She's also unaware as to why it wasn't made. Everything was set up for him to appear. He just did not appear. So I'm unsure as to why not, and I know that Ms. Graham is unsure as to why not as well.
And I do think it's actually the third one as I look through the notes in my file. It's at least the second one, I know for sure. I feel, on behalf of the people, I'm in a different position.
Go ahead.
And at this point, we have to get this moved along, and Mr. Caldwell has not appeared. I understand he has mental health issues, and there are difficulties. But at this point, I am going to ask he has violated his bond conditions by not complying with the court's order to appear for the forensic interview, and I'm requesting a bench warrant.
At this point in the hearing, the situation has officially crossed from procedural delay into bond violation territory. When the prosecutor requests a bench warrant, that's not just a suggestion. It's a legal response to repeated noncompliance. Mr. Caldwell was ordered to attend forensic interviews, and missing them multiple times means the court can no longer rely on voluntary cooperation. Here's the legal reality. Bond conditions exist to ensure defendants follow court orders while remaining out of custody. When those conditions are violated, the court has the authority to revoke bond and order arrest. That's exactly what the prosecutor is pushing for, because without Caldwell physically present, the case cannot move forward. The defense tries to explain the missed appointments, blaming paperwork issues and prior counsel confusion. But judges don't just look at excuses, they look at patterns. And this pattern shows repeated failure to comply. The judge's tone shifts here. You can hear the patience thinning. This isn't about punishment yet, it's about control. The court needs to regain authority over a defendant who's clearly slipping out of reach. So let's ask you, should the court have already issued the warrant by now? Or is one more chance fair?
I don't know if we're going to get it done without him in custody.
Well, it looks like 3 to me.
Your Honor, what had happened, I came in, I replaced a prior attorney. You actually appointed me to this matter. And the first one was, I don't know if it was the first or the second, but one was set and they did not notify me. They notified prior counsel. So that's when they messaged us to reschedule that one. That one was missed because of the, there was a mix up with paperwork, but in this one, so this was the second one that's for me, Your Honor.
Okay, here's what I'm going to do. I'm going to indicate that the defendant is to surrender to the Washington County Jail. Oh, somebody else has their hand up.
I think they lowered it, Judge.
Your Honor, that's Yvonne Davis. She is the owner of Elite Guardianship, who I work under.
I'm sorry, she is the
owner of Elite Guardianship, the company that I work for. So she
yes,
also
ma'am.
is. So that's why she has her hand up.
Okay, is there something you wanted to tell me, Miss Davis?
Yes, Your Honor. So unfortunately, Mr. Demetrius Caldwell has been very difficult to get him to any appointments. His behavior is disturbing, at least. He's been very disruptive at CMH as he is right now, waiting for his court case. He's technically homeless, and getting him to another appointment is basically impossible. So I wanted to add that.
Okay, thank you, ma'am.
Yes,
you're welcome.
Your Honor, can do something soon because I can tell he's getting a little agitated with Miss Nina that's there, and he's already.
This is where the case takes a serious turn. We now learn that Mr. Caldwell isn't just missing appointments. He's allegedly disruptive, agitated, and even throwing chairs while waiting for court. That kind of behavior changes everything. Courts can be understanding about mental health struggles, but they cannot ignore safety risks. When someone becomes physically aggressive in a courthouse, it stops being just a compliance issue and becomes a security concern. The judge's job isn't only to protect the defendant's rights, it's also to protect court staff, attorneys, and the public. Notice how Caldwell immediately denies the accusation and becomes defensive, using casual language like bro with the judge. That's not just disrespectful. It signals a lack of understanding of courtroom hierarchy. Judges expect professionalism, even from defendants. The judge now pivots strategy. Instead of issuing a warrant immediately, he orders an in-person hearing. Why? Because sometimes direct supervision is the only way to regain control of a case like this. So here's the big question. Is the judge being too patient or showing the right amount of restraint?
Already thrown a chair while he's been sitting there waiting on you in the courtroom.
Where is he right now?
CMH on
talk to them. Please talk to them. You please talk. I did not throw no chair or nothing. I've been sitting here chill all day, bro. Why is y'all on me like that, bro? I did not do nothing wrong. I'm not doing nothing wrong. I've been sitting here all day, trying to get up out of here, waiting for my appointment.
All right, Mr.
I'm not doing
Caldwell.
nothing, bro.
Okay, hold on. He's talking.
I've been chilling, like I'm not doing nothing wrong.
Okay, Mr. Caldwell. Mr. Caldwell, you'll need to come back on the screen and sit down, sir. All right, thank you. So, Mr. Caldwell, our problem is that we've got to have you get to your appointment, and you can't get there.
Okay, I literally said I would reschedule it to go to it. I literally just said that. Like, I've been saying that.
Okay, but hold on, Mr. Caldwell. We've done that twice now. Okay, and you've got to get to the appointment, otherwise we can't do anything, and then I've got to do something I don't want to do.
Okay, I said I would reschedule it and go to the appointment. Can y'all reschedule my appointment so I can go? I just said that I would literally go to my appointment.
Okay, I'll tell you what, Mr. Caldwell, here's what we'll do.
That's all I said. Been done. Said.
Mr. Caldwell, listen to me now. Listen to me.
I'm listening.
All right. I need you to come down to the courthouse. I'm going to set an in-person hearing where I can make a decision on how we're going to get this done. I'm going to set it for next week, the 11th, 2025 at 9 a.m. So you need to come down in person, and then I'm going to decide how we're going to do this.
All right.
All right, but you got to be here.
I will
And
be there.
what
You
I
said
don't,
11. You
and
said 11.
Mr. Caldwell, hold on. I don't want to have any of those reports of that behavior that they tell me that you're doing. You got to
I'm not
behave
doing
yourself. Mr. Caldwell,
I'm listening,
what
but
did I
I'm saying
just
I'm
say?
not.
Okay. I'm not blaming you. I'm not making, I just don't want any reports of that. I'm going to give you a chance to come down here so we can try to work this
Okay,
out.
I heard you. I heard everything what you said. You don't got to explain it no more. I heard you, bro.
Yeah, I'm not
11,
broke.
I will be there.
I am not broke. I will never be your bro.
I didn't say, bro. I said, all right.
Do not refer to me that way, because we're going to have a bigger problem.
I didn't say, bro. What are you talking about? I said, all right.
Your Honor.
Your Honor.
Thank you.
Your Honor.
We'll see you next week.
All right.
Thank you, Your Honor. We'll see you next week at 9 a.m.
Pardon?
I said, thank you,
9
Your Honor.
a.m.
We'll see you next week at 9 a.m.
Thank
Yes,
you.
ma'am.
Thank you, Judge. Have a great day.
Yeah, you do the same.
Okay.
You do the same, bro, too. What? What? Who is? Who's that? Janelle? Where's Janelle? Janelle? Miss, I can really? What were you guys doing over there?
Someone told a joke. It was really funny.
Was it a funny joke? Tell us all, because we heard the laughter, but no, what was the joke?
You know, sometimes like after all the laughter, you forget the joke.
Is that how that works? Okay, all right. I just wanted to make sure we heard you, and like Mr.
This
Killers,
courtroom
like,
exchange was
jumped
more than
'cause it
just
was
tense.
so loud.
It was a clear
It was-
demonstration of how
and-
fragile the balance is between compassion and accountability in the justice system. Mr. Caldwell's repeated failure to attend court-ordered forensic interviews placed his bond at serious risk. The prosecution was justified in requesting a bench warrant, while the defense attempted to explain the absences through miscommunication and mental health struggles. Meanwhile, reports of disruptive behavior raised legitimate concerns about courtroom safety. Instead of immediately issuing an arrest warrant, the judge chose a middle ground, ordering an in-person hearing to regain control of the case and assess Caldwell's behavior directly. That decision reflects both caution and fairness, giving the defendant one final opportunity to comply before harsher consequences follow. But the message was clear. Court orders are not optional. Respect is not negotiable. And patience has limits. Now we want to hear from you. Do you think the judge made the right call by giving one more chance? Or should the bench warrant have been issued immediately? Backhand index pointing down, drop your thoughts in the comments. And if you found this case as intense as we did, make sure to hit that like button, share this video, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.